Hey, thanks for joining me live today. This is Anthony Parent of IRS Medic, and I have up on my screen a little segment of an article. This is a paid article I get, so I can't show you the whole thing, but this is on law360.com, and it made me immediately think to create a video because who said what? In this case, this is an analysis by Kat Lucero. Again, I can't show you the whole thing because of licensing restrictions, but this is the claim that a direct hit on tax regulations is unlikely if justices ditch Chevron. Okay, and I'm going to go over what this exactly means, and really what this article goes in. If you were happen to scroll down because you had a subscription, what this article would say is that many tax academics are making this claim. It's not other people, but these are tax academics who are claiming that if the Chevron deference standard is removed, there won't be much change to tax regulations. Well, because these are tax academics speaking, I immediately became suspicious of the claim. And actually, I have been suspicious of this claim. So let me tell you exactly what's going on here in this case. I'm going to go over here to, now I can show you this full case here. Let me go ahead and show you this full screen right here. This is a case called Loper Bright Enterprises Incorporated versus Gina Raimondo. And this is a case, and this website is published by the plaintiffs in this case. The Supreme Court takes the case to consider the future of Chevron, the Chevron standard. There's a video here, and this is what it essentially gets down to. This is what the case gets down to, and now this case has nothing to do with U.S. income tax. Rather, this has to do with some regulations of the Magnuson-Stevens Act. The MSA gave the National Oceanic and Atmospheric Administration, NOAA, the authority to require monitors on commercial fishing boats. Now, here's the thing. The law said, okay, hey, look, certain large vessels have to pay for their own monitor, but smaller vessels, it was silent to. It didn't say the smaller vessels had to. Well, what happened was NOAA goes ahead and decides, well, you know what that means? That means that small boats have to pay for their monitors as well, that they're the people, their own government officials to be on the boat and to monitor it. Now, here's the thing. It's really, really expensive to do so. And oftentimes these monitors, the government monitors can make more money than the ship's captain for being there. So this case was brought to say, hey, look, these federal regulations really don't seem to be in line with the law. The law says, okay, large ships should be able to pay for their own monitors, smaller ships don't, but the result is the exact opposite. So this is what and this is really what's important, why I mentioned Chevron before. However, due to a legal doctrine called Chevron, which was established in 1984, when a law is ambiguous or silent about what is required in a specific situation, federal courts must defer to regulatory agencies like NOAA and their interpretations of the law in question. In other words, when the Chevron doctrine applies, federal courts are not engaging in the constitutionally mandated role of deciding the meanings of laws and regulations. And that's really what this is all about. And in this case, the law was silent about who's responsible for paying herring boat monitors. And so some lower courts have been forced to reject the petitioner's claim to challenge these costs, even though they likely agree with the fishermen in principle. So this is really what's going on here. So Chevron might get overruled, and this is really what it is. And this is what I learned in law school. Chevron's a rubber stamp, basically a rubber stamp. That federal courts are out of the game. Because if we're going to give deference, and this is sort of where I think things go totally wrong and completely backwards, the Chevron standard would make it seem as if the reason why the United States of America exists as a country is really for no reason whatsoever. The founders of this country weren't suspicious at all of governments, but rather they trusted governments to always do the right thing for the people they claim to represent. And that's why we should defer to them. But of course, nothing could be further from the truth. The federal government will take care of the federal government first. And our founders were actually incredibly suspicious of federal power. So it doesn't make a lot of sense that the Chevron standard, which was completely invented by the court. There was no law; they just invented it to say, "Hey, look, we want our friends in the federal government to do whatever they want, regardless of the law passed by Congress." Now, here's how it applies to the U.S. tax code. Okay, so this is a Chevron standard, right? The Chevron standard is just saying, okay, if a federal agency has an interpretation of a law, it's got to be the law. What could be wrong with that? Well, let's back up a little bit, because actually I think that there should be severe consequences for individual income tax. And here's why. I'm going to go to it. So I'm going to first start off here. I'm going to share my screen here of, this is the code. This is our tax code. And oftentimes when people would comment on my channel to say, Anthony, show me the law that shows the U.S. government could impose income taxes. Well, this is what I would link to. 26 U.S. Code Section 1, tax imposed. This is the beginning of the income tax. And this is really it. But something was very, very unsettling for me when I would share this logical link. The way this is written, it really doesn't say it. It just says 26 U.S. Code Section 1, tax imposed. Okay, so we get to this. The very first line is A, married individuals filing joint returns and surviving spouses. Okay, that's where we start. And then we get down to the next section here, heads of households. Okay, then we get to C, unmarried individuals other than surviving spouses and heads of household, and married individuals filing separate. This seems like a weird way to start off an income tax. If you notice something, and this is really the problem here, the code isn't defining what it means to be an individual, right? It doesn't. It says all we know about individuals from the actual law is this: an individual can be married, can be widowed, or can be single. And can have children, can be the head of household. That's all we know about individuals. But there's a lot more to do with an individual than just their marital status, right? So now one thing I want you to think about that you're probably not thinking about, but it's something that I think about because I always deal in the worst situations where the tax code is dropped on people like a hammer. Think about this. This is the law, yet think the law per the Treasury regulations, and I'll show you those right here. These are the Treasury regulations. Okay. And in the regulations, we actually find the definition for individual, right? The law doesn't define individual other than saying, okay, they might be married, single, or widowed, or have children, right? Because the question is like, well, what about somebody under 18? Would you consider them to be an individual? What about somebody who is mentally disabled? Would you consider them to be an individual? What about somebody who is physically disabled? Are they an individual? What about somebody overseas? What about somebody on the moon? What about somebody on Pluto? What about anyone in the universe? We don't really have that definition, right? So these are the things, like, because I think most of us would agree that we shouldn't be throwing this awful income tax, which just starts here, on people who can't handle it, right? This is supposed to be a progressive income tax that's supposed to punish and burden the wealthy and the strong more than the weak. But we could definitely say that based on what we're seeing here, it's punishing the weakest of the weak. Newborn babies are fully individuals to the income tax, and they have an income tax obligation. Now, worse, when we think about this, it's even worse than this. It's even worse because your income tax filing obligations are a non-delegable duty. And what I mean by this, and this is what I tell people who hire us, like, hey, look, we're going to sign your returns. We're going to do the best thing we could do. But ultimately, you are on the hook for what we put in there. Then you would say, well, geez, that's not fair, Anthony. I don't understand the income tax like you do. I don't have the experience. I don't know what these terms of art mean. And I would say, yes, you're exactly right. It is completely unfair. It is completely unfair that the tax code is so complicated that you need to hire a specialist to help you understand it. Yet the code won't allow you to say, well, that specialist told me to do that. Don't penalize or harm me. The IRS may still penalize you and harm you, even though you had no clue of what you were doing and admitted to such. They could still come down hard on you. We had one case where the IRS was assessing penalties on a gentleman who was in a coma. He was actually in a coma the entire year. And the IRS says, well, that's not reasonable cause. You should have known. You should have known that you had this filing obligation. Again, he was in the coma. But that's what happens when the Treasury Department gets to define what individual is, right? That's the problem with it. Now let's go to, so here's the regulations here, and I have the links in the description, by the way, if you want to follow all of these. Now, does this seem at all reasonable to you, right? Do you think a baby should be taxed the same way as an adult? Should someone be disabled be the same as any individual? Doesn't it seem a little cruel that the income tax is imposed on the weakest in society the same exact manner as the strongest? Don't you think there's a disconnect between the law and the regulations? And that's really the important decision that I hope the Supreme Court is going to decide. Well, I hope in Loper versus Bright, they come down and strike down this Chevron doctrine that makes no sense. It makes no sense. And it's clearly unconstitutional because it's taking the federal judiciary out of the role of determining what laws actually mean. Right? What a law actually means is now somebody who's not elected. It's just a bureaucrat. Their feelings and opinions on this, regardless of what the public want, regardless of what someone who voted for the law want. Now, as we go down here, so, and this is what I said before. Again, federal regulators and academics often work hand in hand. It's sort of a revolving door. You work, you're a professor, you go work for the government, your government go be a professor, because they work hand in hand. Again, I think the law, what the result of this will be 180 degrees from what the academics claim is going to happen. Because really, if Chevron is overruled, the government has a significant problem with the individual income tax. Congress did not define what an individual is, or if they defined it, this is the thing, they implicitly admit an individual is someone who could be married, single, have kids, or be widowed. Okay. Well, that means that would be somebody of the age of majority, right? If you look at this, right? If you looked at these sections about from the law, because this is the only place where we find it in the law, married individuals, heads of household, unmarried individuals, other than surviving spouses and heads of households, and married individuals, right? Those are the four types of people. Wouldn't you think that would mean somebody would be 18 years or older, right? As we're describing it. Now, of course, there are unmarried individuals, right? So that can be somebody who technically is under the age of 18, but in context, is that how you would refer to a baby? A newborn baby? Would you say, oh my God, look at that beautiful unmarried individual. Oh my God, looks just like you, doll, right? Would you expect that? No. Unmarried individuals, you would think, okay, this is all requiring people over the age of 18 and people who are functioning adults. That would be the normal assumption that we would have. And if we go over to this site here, marriage age by state here, there's some states where you can be married at 16 and some at 17 with parental consent. Some you have to be 18 or over. You would think this would these are the ages that would actually be relevant to determine if somebody is an individual or not. Because let's think about this, right? Here's really the indictment of all of this, right? And I've talked about this before. We have the most complicated tax code on the planet by far. Most complicated thing in the history of complicated things. There's nothing as complicated as the U.S. tax code, nor will there ever be. It is truly superlative in every way imaginable. So let's think about this. Let's say, what is the average reading comprehension of an American adult? And the answer is about 6th grade. And then the question is this: What's the average reading comprehension required to understand the basic Form 1040 instructions? And the answer there is the 11th grade. So the question is, why would Americans vote to be subject to a punitive, and I mean the world's most punitive, the world's most all-encompassing, the world's most awful tax regime that they can't possibly understand? I mean, look, most even highly educated PhDs and engineers, even tax attorneys have a problem understanding the tax code. So why would Americans agree to be punished by things they can't possibly understand? And the answer is this: they wouldn't. Of course they wouldn't. And the reason why is because the income tax regulations do not reflect the will of the people, and they actually don't even reflect the will of Congress. Rather, they reflect the will of our bureaucratic state, the government. So the question is this, and I really hope people respond to me, and I hope I generate some response and some people who disagree with me. But will the Supreme Court continue to rule in favor of the government's interpretation of law, or will it reflect the will of the people whom the government is supposed to represent? With that, this is Anthony Parent concluding this, and I hope again that some of you will come and tell me where I'm wrong on this. Tell me where I might have gone off the deep end here. Here's Chevron here. Here's a link to the Chevron summary here on Wikipedia. And here is and oh, by the way, before I leave, I did read this. This is an amicus brief, and I think this states it so well here. This is really where I want to conclude. This is the amicus brief of, who is this here? This is the amicus brief of the Center for Constitutional Jurisprudence in support of the petitioners. Attorneys John Eastman and Anthony Casso are on this, and I really, really like this one. This is where they say it. I'm going to send this video to them too. I think hopefully they'll like it. This is what I love here, right here. Summary of the argument. This is so perfectly stated, folks. The framers and ratifiers of the Constitution were not attempting to design an efficient government structure. Because the reason why they're saying that is because the people who said, oh, no, we should allow these unelected administrative agencies to come up with these rules, because otherwise it's going to be too complicated, take way too much time to figure it out. So let's just shortcut everything and give all this power to these administrators, bureaucrats, because otherwise we can't get anything done, right? But that is not why the Constitution was signed into law. It was not to design an efficient government structure. Instead, they sought to design a federal government with an authority to act, but that was bound by checks and balances as a mean of protecting individual liberty, right? Right? None of us would ever vote to be subjected to this, right? Would you vote to be subjected to a law you couldn't understand and that you couldn't hire an expert to understand for you? Of course you wouldn't, right? The design they settled on, that is still present in our Constitution today, is a finely tuned separation of powers. The powers of legislation, execution, and judicial review are housed in separate and competing branches of government. The framers and ratifiers recognized that the power of legislation was the biggest threat to individual liberty, and so they incorporated procedural hurdles to slow down the process of lawmaking. Congress is granted all legislative power authorized under the Constitution, but that power is constrained by bicameralism and presentment requirements, right? Now, this is the thing. Now, why did they italicize all? Well, because we don't want unelected bureaucrats to be determining to making law. And that's what's happening. When we have a law that says one thing, then regulations that say something kind of different, that's a new law that's being made, right? The exclusivity of the vesting clause and the restriction on how the legislative power may be exercised prohibit delegation of that power by the executive. You just can't hand it off to someone. Yeah, you take care of it, right? And that's what's been going on for a while here. That's why Washington, D.C. is one of the wealthiest places in the country, not because they produce anything valuable, but specifically because they don't. That is the problem that Congress seeks to address is complex and irrelevant. The framers and ratifiers did not include a complexity exception to these checks and balances. As demonstrated in this case, administrative agencies are a threat to the design of separation of powers if they operate in an atmosphere divorced from the structural separation of powers. This court noted just last term that executive agencies are more than capable of asserting sweeping and consequential authority never contemplated by Congress. And they cite the West Virginia versus EPA case, which was an incredible case. I can't even believe that the Supreme Court ruled that way, which said that, you know what, if you're going to pass a regulation, it actually has to have something to do with the law. Just can't invent new things. And so that's why, I think with the current composition of the court and the fact that they actually decided to hear this case, and because they actually ruled against the government in West Virginia versus EPA, they took on Loper Bright, which, factually is, this is really, I think it's well argued, well presented. This case is not just a case about some bland government interpretation, but this is really driving herring fishermen out of business. And I think so. I think the attorneys have done a wonderful job on explaining what this case is actually about. The Supreme Court seems poised to rule in their favor. And so if Chevron is overruled, I actually expect to see changes to tax regulations. Now, this is the big one, right? That's the thing. I'm talking about the inception of it. So let's just think, so if there's actually a problem with the entire individual income tax, I think we're going to find other problems in some of the lawmaking that the Treasury does. And in particular, if you watch this channel, you know that I've gone through and analyzed the Bank Secrecy Act, the FBAR reporting requirement, because the FBAR regulations say that 31 USC 5314 authorize a report of foreign bank accounts, and that is not true whatsoever. It authorizes a report of foreign financial agents, and the law specifically defines foreign financial agents and foreign financial institutions as totally different things. And so that would be an amazing thing as well. So with that, according to law, I would say the U.S. income tax has to go away. But the truth is, the federal government is all on the same team. And so that might be a little bit too much. I could see the Supreme Court ruling in favor in removing the Chevron deference, but not giving the deference to the income tax code. That might be a little bit too much for our Supreme Court, because that would radically change everything about U.S. taxation. This is Anthony Parent and Parent LLP, IRS Medic. I thank you for watching. And again, I really want to hear your comments and what you think about my theory that Chevron, the overturning Chevron, may actually overturn our individual income tax. Thanks for watching.